The Climate Change Commission and the government are encouraging businesses to collaborate on efforts to decarbonise the economy. But companies need to be conscious of when that collaboration might cross the line into anti-competitive behaviour. Buddle Findlay partner Susie Kilty joins me now via Zoom from Wellington to talk about the grey area here. Kia ora, Susie.
Kia ora.
So where is that line between collaboration and collusion, and what are the regulations that businesses need to have in mind when considering collaboration?
Well, the first thing is to acknowledge that innovation can be risky and expensive for businesses, but it is necessary, particularly when we're facing challenges like how do we decarbonise our economy. And so then the next thing to know is that collaboration between businesses that aren't in competition with each other, that don't compete in their markets, they can get together and just go for it, basically. But for businesses that do compete, they need to think about the effect of their conduct on the effect on competition between them, and they need to take legal advice. So for us in New Zealand, the key piece of legislation is the Commerce Act, and that act prohibits cartels and other anti-competitive arrangements. It's general legislation, so where the line is needs to be looked at in any given situation, and whether there might be an approval or an exemption that might be helpful as well.
Okay, so we are seeing some interesting cases overseas. In Austria, for instance, they've made an exemption to their Cartel Act for agreements that contribute to an ecologically sustainable and climate neutral economy. So is that sort of an approach that we need to follow in New Zealand, or do we already have some of that wording in the Commerce Act?
We don't have that wording, but I'm a big fan of the flexibility of the Commerce Act. It has enough latitude as it's written currently to enable businesses, to support businesses to jointly innovate and to pursue environmental goals, provided that when they are getting together, their restrictions, if any, on competition aren't going further than is necessary. So, for instance, if there's a regulatory timeframe that businesses must meet, and a business looks at that timeframe and determines that it doesn't have enough time to actually meet the requirements, then getting together with a competitor to advance development, manufacture, and roll out a particular technology or an innovative solution, that needn't be problematic under our law, but letting the arrangements spill over into other areas will be.
Okay, so I can see perhaps where companies might want to seek clearance or pre-authorization for something they're considering. Is that an available option?
Yes, so we have a couple of different pathways that businesses who want to collaborate can go down. So first of all, there's a clearance process for collaborative activities that include a cartel provision. So you can apply for clearance to the Commerce Commission, and that could be, for example, jointly dealing with an infrastructure supplier to help the collaborating parties get this required scale to advance their proposals more swiftly. The second pathway is through authorisation. So an authorisation can be also granted by the Commerce Commission, and that process involves an assessment of an arrangement between the competitors, and an authorisation will be granted when the public benefit, and that's where environmental benefits can come in, exceed any detriments to competition. So at the moment, that authorisation process relates to arrangements lessening competition, and from April next year, it will also cover cartel arrangements as well.
Okay, and was there a case recently, Tasman and Nelson councils seeking authorisation that you've mentioned to me? Tell me a little bit about that case.
Well, that case is actually, that was actually a merger case, but the point there is that the Commission expressly considered the environmental benefits of those two councils combining their business unit to run their existing landfills, and they recognised that there could be environmental benefits, but in that particular case, the authorisation was justified as a result of other, economic benefits rather than necessarily needing the environmental benefits to be determinative. But it is promising that the Commission has shown a willingness to look at those things.
Okay, so do we need further case law and precedent in this area to sort of flesh things out a bit?
Yes, well, we do have the advantage of a regulator, the Commerce Commission, that does publish quite extensive guidance that is always the starting point for businesses and their advisors. And that will show insight into how the regulator might think about these issues. Secondly, through the clearance and authorisation process, we also get the benefit of published decisions, and that will show how the Commission applies the law into those specific sectors or industries. And again, they're a great source for us as advisors and also as businesses to get some guidance. Case law, yes, absolutely. Precedent through the courts can be useful, but naturally you always hope that it's not your business that's the subject of the precedent.
Sure. And this sort of product stewardship schemes as well might sort of fit into this as well. Tell us what those schemes are and how they might be affected.
Yes, that's right. So under the Waste Minimisation Act, the government can declare certain products to be priority products for stewardship schemes aimed at transitioning from a linear economy to a circular economy in terms of product consumption. There are about six so far, six or so, covering some familiar products such as plastic packaging, electronic products, and tyres. So product stewardship schemes can be regulated schemes with accreditation, but of course, industry bodies and industry sectors and participants in those sectors can decide to put together their own product stewardship scheme if they see the writing on the wall, for example, for potential future legislation anyway. Either way, participants need to be aware of the Commerce Act and how the Act might apply to the scheme, particularly when you have competitors involved. For example, if a scheme was going to involve a proposed agreement as to how to fund or pass through funding costs to consumers, then that could be something that the Commerce Act would be interested in and may be breached. So these schemes aren't specifically provided for under our Commerce Act, but again, you have the clearance and authorisation process that I mentioned just a short time ago. And the Commission has also published a specific product stewardship scheme guidance that's really, really useful for companies to take a look at.
Okay, and so what other top tips would you give for companies who are trying to protect themselves against getting tied up in any cartel activity?
So the first thing is seek legal advice and seek it early. Because it's a bit of a pain for businesses if their lawyers aren't involved earlier enough and then have to unwind what they've already started. But it's also even worse if the regulator later on decides that there is a problem and unwinds and penalises actions by businesses. So legal advice early. Establish a clear purpose for any collaboration. Why is it necessary to get together with competitors? Articulating what they want to do, why they're collaborating, as I mentioned. For example, do you lack resources to meet the timeframes and so on? And then putting in place robust processes and competition protocols to govern, say, joint discussions and meetings and so on, and sticking to them through the process. But ideally, you get your legal advice early on, and then the parties can go off and innovate and achieve what they want to achieve.